my name is Carly Forrest, partner in the insurance and risk team at Brodie's, and it was advertised with Gemma Nicholson, senior associate. However, poor Gemma is ill today, so Katie Angus has stepped in to take over for Gemma. So thank you, Katie, for doing that. But you're going to hear from both of us today, and we're going to talk about personal injury claims, and specifically the thorny issue of costs, which is so relevant to everything that we do in the world of claims. This autumn really has seen the publication of a number of cost decisions in Scotland, so it's a really good time to revisit parts of the claims processes and look at the protocol for pre-action, QOCS and judicial accounts, and really looking at what point have we reached now, and more importantly, what that means for decision making in terms of tactics and strategy on claims. So the focus today is very much, we just kick on to the next slide, we're looking at new developments and decisions, but before we delve into those, I just wanted to mention that there's no change to the stepped fee scale, so we've got that on the next slide. Basically, this is the status quo that applies to pre-action claims in Scotland. One thing to remember about this fee scale is that it's directed towards actions with a value of not more than £25,000 in damages. Now, where a claim is in excess of that value, the fee scale is not mandatory, but it is open to parties to be able to agree it. Now, if that step's taken for higher value cases, it sometimes means that the pre-action fee is actually going to be greater than what the pursuer could recover at the early stages of litigation. And also where the case involves multiple claims, so for example, a fetal case, it can also mean that different ways of applying the stepped fee scale can produce different results depending on if you look at it as individual claimants or you look at it as a global settlement. One thing I would just add in there about, sometimes things are litigated, it's not always a bad thing because it allows you to take control of the process. So what I mean by that is that actually you can then take control by having the tools to recover documents, to recover evidence, to be able to lodge a tender, to look at different strategies. So just bear that in mind. And also I think it's worth mentioning that in higher value cases, that a more bespoke approach might be needed. So looking to agree a specific figure for solicitors' fees rather than simply making an offer and then saying in blanket terms with protocol costs, because you want really to have the certainty of outcome and also avoid the potential for a windfall that you didn't potentially know you were signing up for. It's been unusual in recent times for cases about pre-action conduct to come before the courts. And that's largely been because since the compulsory pre-action protocol came into force, pursuers agents have, for the most part, aligned conduct to the spirit and the terms of the protocols. That said, and I'm not naming any names, but in recent times we have started to see some bad habits creep back in. And to the extent that they have, the decision on the slide in McInnes is a good and it's a really helpful reminder of expectations on parties. And really, the big point to take from this is that bald rejections of offers with no stated factual or legal basis to support that rejection just isn't enough to be deemed protocol compliant. So you can't just say the offer is rejected and that's that. Where they are used and litigation follows, this tells us there's a basis to ask the court to limit the pursuer's expenses to those which would have been due at a pre-action level. So I've given you the case reference on the slide and I've set out here the key parts of the judicial finding. So it is a useful decision to quote to the other side if you are receiving just a bold response in response to an offer, but you're also keen to bottom out if the claim is capable of agreement. And hopefully by using this, that should promote a more open and meaningful dialogue in return. There have been, as I'm sure you're aware, a lot of new QOCS decisions, which we're going to share with you, and Katie's going to come on to talk about those later. But before we look at those, I just thought it'd be worth looking at case numbers and types, which are relevant to the overall cost of personal injury litigation in Scotland. The first point to note, if you look at this slide, is that there are more personal injury claims in terms of actions raised last year than the year before. There's been a 12% increase. Now, these are the latest figures that have been published. They're still lower than pre-pandemic levels. And as in terms of type, you'll see that more than 1 in 2 claims raised relates to road traffic accidents. I think we certainly are seeing an uptick in the number of claims, albeit, as I say, not quite pre-pandemic levels yet. I think what that also shows is that the compulsory pre-action protocol is working and cases are managing to be settled. In terms of forum, the personal injury court has the highest number of actions, but we're still seeing local sheriff courts most often used to litigate on road traffic matters. And I suspect that's because, in all likelihood, locus is so important to those cases, and that's perhaps why we're seeing them being litigated there. And I think that brings us on to looking at QOCS, and I'm going to pass over to Katie to take you through that.
Yes, yes, thank you, Carly. Yes, so we're going to have a wee look here now at the operation of QOCS in Scotland. So, it's been a feature of our legal system for more than 2 years, and the default position is as set out on the slide, namely that costs protection is now afforded to the reasonable pursuer. That said, there are exceptions. The Scottish exceptions, so if we look at the slide, the Scottish exceptions are set out on the right-hand side of the slide. And initially, we had certainty as to what the exceptions were, but no clarity as to how they would operate. And securing that clarity has now been helped following a number of recent decisions in the autumn of this year, as Carly mentioned. This slide, we've set out the chronology of those QOCS decisions. The first 3, Lennox, Gilchrist and Love, they represent unsuccessful attempts to engage the exceptions. Those decisions, however, did include helpful commentary as to what may be relevant to each exception, but as defence agents, we were still waiting to see precisely where the trigger point, as it were, for their operation was. We knew the bar was high, but the question was, what that we had was, could it be overcome? As we move on to look at each decision, we're going to consider what has been said generally about the trigger point for each exception, and thereafter what findings are needed to allow that trigger point to be reached. To adopt that approach is deliberate. It reflects that any decision made on the exceptions is a discretionary one, and it's made by the court, having regard to the specific facts and circumstances of the case before it. Previous cases are always open to being distinguished, and so it's helpful to focus on what the transferable aspect of each decision might be. So the court's approach, firstly, to the abandonment exception is short and precise. Namely, if abandonment occurs, then QOCS will be disapplied. Sheriff Fife was clear in his rejection of the proposition that this step could only be taken if there were additional factors to support that the pursuer had acted in an unreasonable and improper manner. In his view, as set out on the slide, the fact of abandonment was in itself enough. And I was a bit ahead of myself there. It's the next slide that has the relevant quote from the judgment. You'll see there, if it was intended that abandonment required to be in circumstances analogous to the other exceptions to QOCS, then that would have been expressly stated. So moving on now to the decision in Carty. Carty confirms that the manifestly unreasonable exception must be approached on the basis of what is set out on the slide. One clear trigger, which has been identified in the prior case of Gilchrist, was positively endorsed in Carty, and it's highlighted in red on the slide. Namely, where the pursuer was found to be incredible on a core issue. So it was something more than being inaccurate. The exception applied where a positive finding was made that the pursuer couldn't be believed as truthful. That trigger is relevant to the later decisions, which we're going to consider, of Musalowska, and of Ali and Hussein. As set out on the next slide, in each of those decisions, the court did make a positive finding that the pursuer was not a credible witness. CARTI, as well as providing helpful clarity on one trigger, also appears to have formally created another, and that's one which relates to a persistent failure by a pursuer's agent to follow due process. So moving on, this slide very briefly summarises the key trigger behind each decision made to disapply QOCS. The decision in Murray v Boots, that case has not been formally reported, but it has been shared. And it's not surprising that a pursuer's decision to raise an action, but not then formally proceed with it, would be viewed as manifestly unreasonable. To place each decision in context, we're now going to turn to look more closely at the actions and interactions which prompted each decision. So in CARTI, the pursuer's agent had not complied with the lodging deadline for the pursuer's valuation or for the record, and had not sought to correct either issue until 5 weeks before the initial reserved diet of proof. After settlement was reached, she also failed to lodge the required motion to dispose of the action on time. The agent also repeatedly failed to revert to the defender's request to provide GP details and a correct date of birth, as well as to provide productions. Sheriff Campbell held that these persistent failures to comply with the timetable or to engage in a timely fashion with the defender's agents was conduct in the management of the action which could be classified as manifestly unreasonable. He accepted there were mitigating reasons for what had happened, namely the dissolution of the firm instructed for the pursuer and the reallocation of business, but did not consider these factors diluted the obligation of practitioners to their clients and to the court. Notably, there is no direct reference in Sheriff Campbell's decision to the relevance of the case having settled because the pursuer had ultimately accepted an offer which had been made pre-litigation. It's not mentioned, but it's hard to imagine that it did not play a part in the decision. Moving on to Muzelowska. In this case, the pursuer had been involved in a road traffic accident. It was accepted by the defenders insured that there had been a collision between their car and the car in which the pursuer was a passenger, but the circumstances in which that collision occurred and whether or not the pursuer had suffered injury remained in dispute, and the case went to proof. At the proof, Sheriff Keir concluded that neither the pursuer nor her witness, who we understand was the driver of the car, could be viewed as credible or reliable. His view of their evidence was that it contained significant inconsistencies and contradictions. Notably, the pursuer and her partner were adamant that the rear near side of the insured's vehicle was the point of impact and that it was damaged in that area. However, when they were asked to physically reconstruct the incident using toy cars, they both indicated that the rear offside of the insured's vehicle was the point of impact. Further, the pursuer stated there was visible damage to the other vehicle, but the insured was clear that her vehicle was not damaged. The pursuer produced pictures of multiple areas of damage to her vehicle and denied that any of it was pre-existing, but the pattern of damage did not correspond to the type of collision which she had described. As their evidence was tested, the pursuer and her partner then made a serious allegation without any evidence that the photographs produced of the insured vehicle, which showed no damage, had been tampered with, or that the vehicle had been repaired following the accident and that the insured was not telling the truth. The pursuer also claimed to have suffered wage loss due to multiple attendances for physiotherapy for accident-related injuries over a 4.5 month period. But of her 8 absences, only 1 coincided with the appointments attended. The pursuer maintained that her absence records were wrong, but could not provide a satisfactory explanation for the discrepancy. And finally, the pursuer attended with solicitors on the day after the accident and signed a medical mandate for the production of her records, which was sent to her GP. But that was before her only GP attendance, which took place 4 days later. It was against this very unsatisfactory background that both the pursuer and her partner were found to be incredible and unreliable witnesses, and the court held that the threshold for manifestly unreasonable conduct had been met. Moving on, in this case, the insured admitted to slightly touching the vehicle behind, occupied by the pursuers, while he was reversing into a parking bay. Liability was admitted with the proof, which encompassed both the claims, restricted to the consideration of whether or not the pursuers had sustained injury as a result of the collision. Sheriff Keir, having regard to the facts and circumstances of the case and having had the opportunity to see and hear the evidence of both pursuers, concluded that neither pursuer could be viewed as credible or reliable on the core issues. He noted their evidence to be peppered with significant inconsistencies again and contradictions. Notably, both the first and second pursuer described the impact as causing a substantial movement, but from review of the prevailing CCTV footage, it was clear that the movement of the car was restricted to rocking backwards on its suspension. The first pursuer produced pictures of the front number plate bracket and the private hire plate that sat beneath it. Both pursuers alleged that they could see damage to each area, but no other witness could identify any damage from those images. A second set of images had then been produced. These showed cracks to the bracket and to the retaining screw, but these had been taken after the private hire plate had been removed, and the pictures did not include the necessary metadata to allow their date to be verified. There was also significant inconsistencies in relation to the first pursuer's reporting of his injuries. The injured areas referred to in his pre-action claim form were not the same as those described in court, and whilst he asserted that he had sought medical advice, no corresponding entry was within his GP records. The second pursuer had provided a handwritten description of events to his agents and had signed this document. He described the movements of the van in detail, but stated in court he hadn't noticed it at all prior to the collision. His description of his injuries was also inconsistent, differing between his claim form and what he told his medical expert. And whilst he claimed to have attended his GP multiple times, this was not supported by his GP records. So having made all of these findings on the tenor of the evidence, Sheriff Keir held that the threshold for manifestly unreasonable conduct had been met. And overall, it's now clear beyond any doubt that if a positive finding is made that the pursuer is incredible on a court issue, so in relation to what's happened or what was lost, QOCS will be disapplied. But it must be remembered that a positive finding in those terms is needed. It cannot be inferred. And it's also worth considering that the definition applied is of obviously unreasonable behaviour. The decisions here were made easier for each sheriff because there was objective evidence to positively test the accuracy and truthfulness of the pursuer's evidence. This was not a subjective assessment of character. It was an assessment of whether a factual proposition put forward, being the pursuer's position, could be verified as probably true, having regard to all the objective and peripheral evidence. Also of note, as this slide highlights, is that concerns about the pursuer's reliability, so the accuracy of her recollection, which the court accepts is incorrect but honestly held, will not be enough to meet the threshold. And so the next slide sets out the established and now affirmed test for the fraud exception. In short, it requires the court to conclude, on balance of probabilities, that the pursuer or her legal representative had acted intentionally to misread the court. Each pursuer, Muzalowska, Ali and Hussein, were held to have done so. In reaching that decision, the court had regard to all the factors which I have previously described in relation to each pursuer's evidence and which are set out on the prior slides. None was singled out as of particular relevance or of being more important. Although we think, arguably, the fact that each pursuer did positively produce and lead photographs, which the court ultimately did not accept to be a true depiction of accident-related damage, may have been a significant factor. And finally, this slide confirms what has been said to date about the abuse of process exception. This is the exception which has not yet been strength tested, albeit it remains our view that it is potentially the most difficult to engage. The traditional test is adopted, and traditionally findings of this type have been difficult to secure within the Scottish courts. And I think on that, I'm now going to hand back to Carly to take us on to our next section.
Thank you, Katie. Really interesting to hear what's been coming out of the courts in terms of QOCS. And I think also I would just make the point about how important it is when you're making your submission to the court, what findings are you looking for the sheriff to make, basically to set up the QOCS argument for you in relation to the credibility issue in particular. But we're now turning away from whether a positive award of expenses will or will not be made to the pursuer. Let's assume normal circumstances, an award of expenses has been made to the pursuer. We're now going to look at what level of award might become due. So really the key development that we wanted to flag today, you might already be aware of it, is that the judicial hourly rate, which is referenced in any judicial account of expenses, has increased. So for work completed from 30th of June this year, the unit is increased from 164 to £180 per hour. So that's just short of a 10% uplift. So that it really is quite significant. And what that means is that you're going to see costs increasing naturally in response to that, albeit not immediately, because as I say, it's work completed from 30th of June 2023. So, it's not taking us to the levels we're seeing in England and Wales, but it does mean that Scottish costs will increase. That brings me on to the last section for today, and that's going to look at some decisions and focusing on what the court has said about decisions made by the auditor of the Court of Session. So first of all, just provide a short summary of the role of the auditor. In short, once an award of judicial expenses has been made to the pursuer, the auditor is essentially the gatekeeper who decides whether the work included in an account of expenses can be charged for, and if so, at what level. So he performs that role having regard to a very clear rule of court that a party should only be allowed to recover such expenses as were reasonable for conducting the litigation in a proper manner. Now, the court, for the most part, will defer to the auditor's findings due to his experience, but they can overrule a decision of the auditor in very limited circumstances. Just to look at a couple of cases, in this case, the auditor did not allow the pursuer to charge individual fees for perusing the INA reports and every monthly case management report. I think we've all seen these reports, particularly if you're dealing with higher value cases, and a lot of them are, setting out the background of what's gone before, and really it's the end part that tells you the update and what you actually need to know in terms of progress. The auditor did allow some perusal charges, but he restricted those. And basically the auditor was of the opinion that the INA report and the case management reports were instructed for the purposes of identifying and managing the pursuer's care requirements rather than for the purpose of the proceedings. That said, their perusal was reasonable for conducting the case in a proper manner. So for the pre-action work, he increased the block fee to take account of that work rather than allowing individual perusal charges. And then for the reports obtained after commencement of the proceedings, he allowed for the perusal of one report every 6 months rather than for each monthly update that was received. Now, the court upheld the auditor's decision on that, holding that he was entitled to conclude that the reports were all provided for the purposes of identifying and managing the pursuer's care requirements. And the court also felt that the decision reached was clear in principle. Namely, it was reasonable to charge for the perusal of the reports, but that the number of charges claimed for was excessive. The auditor's decision to disallow the read-in time charged following a change in counsel on the basis that this represented duplication of work, that was also upheld, albeit somewhat reluctantly, given the change had been out of the pursuer's hands after counsel originally instructed had become unavailable upon her appointment to Crown Office, but nonetheless, that read-in time was disallowed. I suppose it also wasn't of the defenders doing. Overall, it's an important decision of relevance in terms of reducing costs and catastrophic or life-changing injury claims. And albeit whether pursuers agents may now seek agreement of each perusal fee prior to agreeing a settlement for damages, well, that remains to be seen. That's something that could happen. Kirkwood, this is a case we actually represented the defender in this case. And it was a case where the pursuer, who lived in Scotland and had been injured abroad, had instructed English solicitors to conduct the litigation. Those English agents had then engaged the services of an Edinburgh firm, a small Edinburgh firm, to assist as local agents, but their involvement was really pretty small. The litigation settled in the normal way, with the defenders paying an agreed level of compensation and on the basis that the defenders would meet the pursuer's judicial expenses. In the normal way, a judicial account was prepared, it was lodged with the auditor, but of the sums charged for in the account, less than 5% was for the work of the Scottish agents, calculated on a normal block fee basis. What we did see was intimated as outlays, significant fees charged for the time spent to prepare the case by the English agents, and that was done on an hourly rate basis. Now, those fees were objected to by us, and they were disallowed by the auditor in full. Now, the auditor's decision reflected that the English solicitors had no specialism that wasn't readily available from Scottish agents, and with English agents known to charge more than the applicable Scottish judicial rate, that their involvement had resulted in higher expense. The pursuer appealed the auditor's decision, so it called before the outer house, but it was then appealed further to the inner house. But at first instance and on appeal, the court held that the auditor's decision was correct. The court was quite clear that English solicitors can be instructed and their charges can be recovered as an outlay, but only where they're asked to carry out discrete pieces of work for particular purposes. So the same way you may, in a Spanish law case, for example, instruct a Spanish lawyer to prepare an opinion on liability or quantum under the law of Spain. The work has to be instructed by Scottish solicitors, and it's the Scottish solicitors who are responsible for the general conduct of the litigation. So the decision to instruct must be viewed as reasonable for conducting the case in a proper manner. If the input was reasonable to instruct, then the auditor has to then consider if the level of charge itself was reasonable, having regard to charging rates within that jurisdiction. So here, as I say, the appeal court agreed with the auditor that it wasn't reasonable to instruct the foreign English agents and that charges weren't allowed. So you'll see from the slide, the decision secured a really significant cost saving for our client, and it does provide really helpful clarity in terms of when foreign solicitors should be used, and if they are, what charges ought to be allowed. So in short, they should be used to help prepare the litigation for trial, but they shouldn't be progressing the day-to-day conduct of it within the Scottish courts. And if they do, then according to Kirkwood, we've got authority to say that the charges applied for doing so should be disputed and arguably disapplied. I think that takes us to the last slide for today. Just on one slide, please. Here we are, and this sets out what we consider to be the key tactical considerations and responses which arise from the judicial decisions that we've talked about today. So I don't think there's anything that's particularly new, but what it does tell you is that you have to look to cover all angles and to maximise discounts, and all of these factors have to be kept under review in each case. So that is our summary and our talk through of where we are at the moment. As I say, it has been pretty active in terms of decisions and in terms of what's coming out, particularly in aspect relating to QOCS. So I'm sure we'll be back soon with another update to tell you what's happened in the next 6 months or so. We have time for questions, so I'm just going to, let me see. I think there's one this is quite a good question, actually. Katie, I'll let you answer this one. But basically about common cost building strategies from the other side and what we're seeing there.
Yeah. So I think late. I mean, one of the ones even I was looking at today, we've got late disclosure of evidence, I think, is one we see quite often. So they're kind of elongating the length of litigation. And I think all we can really do to combat that, I suppose, is continually pressing the other side for whatever it is that we've not got yet. And we quite often rely on there's a practice note from the court which makes it clear that any reports held by the pursuer's agent should be released. Obviously the pre-action protocol also has deadlines for when reports should be being disclosed. I say should because it's not always when they are, but when they should be disclosed. But as I say, this practice note also gives further guidance on that, and late disclosure is positively discouraged by the court. I think in terms of just think of our experience of judicial accounts, the one that jumps out definitely is precognitions. So you'll get an account in and you'll have a significant number of precognitions, which helps to bulk up the account, and they're difficult to attack because we will not see, particularly if it's precognitions of a pursuer, for example, we won't have seen those precognitions, and so it's more difficult for perhaps us to combat, although we obviously do give it a good try when we get an account in that's particularly big in that respect.
Yeah, I think that's a fair point. I think also it's worth bearing in mind that be really clear in your correspondence, setting out, thinking about if you are having this argument further down the line or likely to be having it, is your correspondence in such a way that you're happy for that to go to the courts? You're setting it up, you're putting the pursuer on notice of what you're asking for, and you can then rely on that in any argument about expenses at a later date. So just be really clear about that. There's another one here about, can we still have virtual hearings? The answer to that is yes, there still is a basis to have virtual or hybrid hearings, but you have to seek approval from the court to do that. The thing is, it's actually quite an interesting question because in my opinion, it's very based on the case circumstances and the number of witnesses you're likely to have, particularly if liability is in dispute and there's a lot of witness evidence in terms of lay witnesses. I think my view is probably easier to have that take place in person. It's different if it's, one person against other or expert witnesses, probably more used to giving evidence over this sort of forum. But I do think in person is probably better where there are a number of witnesses and liabilities in dispute, particularly when credibility and reliability is so important, as we've discussed today. I think that's all the questions that we had. So it just remains to say thank you everyone for attending and for listening to what we have to say today. But otherwise, thank you and enjoy the rest of your days. Thank you.
Thank you.